the Gartner report, which came out at the beginning of April. It essentially said that the chaotic regulatory environment right now is driving compliance officers crazy. And I talk with a lot of compliance officers. That is indeed true. Specifically, the phrase that Gartner used was that the unsettled regulatory and legal environment, that is now ranked as the top concern for risk and compliance professionals in first quarter 2025, up from the number 3 slot in the prior 2 quarters. Now, think about that, because in the prior 2 quarters, that was latter 2024, we were not certain who would actually be leading Washington in 2025. So you can see why people would be a bit uncertain about that. Well, now we do know who is leading, and uncertainty has gone up. So that's really quite a jarring statement. I love that you use the example of the Consumer Financial Protection Bureau, because it does get at the heart of what does the law say? What are we actually doing to enforce the law? If there is a radical change in how the agency operates, could that be challenged? If it's challenged, is that challenge going to stick? And we could go on for hours just on that case. But if you are a compliance officer at some sort of financial firm, fintech startup, any firm that really somehow offers financial services to consumers, and there's a lot of companies that would say, well, I'm not really a finance firm, so I'm not immune, or I'm not subject to that. Yes, you could be. It's a great example of how you can get pulled into this mess that the law says you have an issue, but you don't know how you're supposed to respond to it because you don't know what your enforcement risks are. Be patient and move with deliberation, which means slow and thoughtful. That is, I've looked it up in the dictionary. Because if you are not moving in that methodical way, you are likely to make a mistake at some point. I will give the example. Let's go back to the Consumer Financial Protection Bureau. So the Bureau may be dismantled. I am not sure, but for argument's sake, let's say all those employees do lose their jobs and they shut it down. The Consumer Financial Protection Law is what companies need to obey. That law is still there. So if you violate that law, you could still suffer an enforcement action at some point in the future. And maybe at some point in the future, those employees get their jobs back. Maybe there is a new administration in 2029. Maybe there's going to be a new budget in 2028. Or, and this is something where people will start to overlook the details, maybe a state attorney general will take up the violation you just made and they'll bring an enforcement action because that's what the law allows. You have to think through that for most federal statutes, the statute of limitations is at least 5 years. Well, that's 2030 from today. We don't know who the president's going to be in 2030. And there are compelling reasons to think it could be somebody very different in 2030. So then at that point, people will look back at, hey, in 2025, you heard there's no more enforcement. We can now have a party and nobody's ever going to care and catch us. We can do what we want. Let's break the law with fearlessness and impunity. That is a terrible idea, and it will look terrible in hindsight. So that's the sort of thing that you want to avoid. So compliance officers should be telling management, just because the risk of us getting caught today might be lower, that doesn't mean we won't get caught in the future. And it doesn't mean we're doing the right thing. If you're breaking the law, it's still breaking the law, even if you're not getting an enforcement action. That is not the right thing. Breaking the law is the wrong thing. We might as well just say it's obvious that the Trump administration is going to take a much lighter approach to regulatory enforcement on many things, although not necessarily all things. And I understand who is on our call today, but go to your HR people and ask them about the enforcement appetite for immigration. And they're going to say, oh, geez, man, this is going to be a nightmare. Or go to your tax team and ask about tariffs. There will still be big enforcement appetite at the federal level for some things, but they're going to retreat on many other things. And that's going to create a vacuum. And that's going to fill in. I will give an example of, you will certainly see state attorneys general using their consumer protection statutes to come in and say, well, we are going to take enforcement against companies on something like their use of artificial intelligence, which can accidentally or intentionally even discriminate against certain people. And so that clearly state attorneys general are going to step in and say, no, you can't do that. They'll enforce against that. There's laws about that. The European Union, as I've said, they are already planning how to fill the enforcement vacuum on something as simple as corporate corruption, which had been a big deal at the federal government. It won't be for the Trump administration. Europe is more than happy to say we're going to step in, but you could go on and on with that vacuum of the retreat at the federal level. It will be filled by state regulators. It will be filled by overseas regulators. It will be filled by plaintiff lawyers who will be more than happy to sue your company on a contingency basis just to see if they could do it. And in many ways, like I said, the risks of doing something bad and the consequences of it, they're just shifting around, but the appetite to hold companies accountable, that's still going to be there. It's a great example because it is one of those risks that I see transforming. Oddly enough, the European Union just imposed a greenwashing claim against a large global bank that I don't think we would see that ESG enforcement claim in the United States anymore. But this was a large German bank. I won't name them here, but nonetheless, they do business globally. And they had been making statements that we have this very environmentally friendly investment fund. That fund was not actually screening its investments for any ESG criteria. And so EU regulators said, that's greenwashing. Here is your fine. I could very easily see state banking regulators in the United States, in certain states, say roughly the same thing. You are making misleading disclosures to my employees or to my state residents. Here is your fine. Greenwashing, I'll put that aside. I still think it's there and it's transforming. But an example of an enforcement risk that is not going away is its cousin, AI washing, where you are an investment firm or a fintech firm saying you use AI to do all sorts of stuff, and you're not. And that's baloney and it's false advertising. The Securities and Exchange Commission under the Trump administration just several weeks ago imposed another AI washing sanction. It had been doing that in the Biden administration. It's still going to be doing it now. So there are examples of other misleading claims. Some of them the Trump administration will care about. Some of them it will care about less. The Europeans will still care about it. The states will care about it. But for the compliance officer talking to management, the question is more like, are we really going to be a company that doesn't care about putting out misleading claims? Because that seems like a really bad thing to do. It's unethical. And if you are doing it accidentally, that means you don't know how your company is performing. That has to be addressed. And you can address it in ways that bear, like I said before, bear a striking resemblance to having a compliance program. Definitely that is a great example. Think about all the risk that we might have had that we have intercepted. Also think through, I will go a little bit different, but customer contact compliance. I think of all of the states that are now adopting their own do not call, do not track, do not text lists. And that is another great example. The feds are retreating from a uniform standard. States are stepping up with their own versions. So you're going to have to navigate all of that. And if you have a very strong compliance program that can track all of the dud calls we never should have made that we didn't make, because we now knew that we could call these people in Nebraska, but we could not call these people in Nevada. So we spent more time in Nebraska, and then you could tie it to more efficient sales activity in certain states than in other states. And how can you weed out or quantify wasted activity that you prevented because you understood we can't do these things without too much risk and we're just going to avoid it? Another great way to demonstrate that having useful, strong, robust compliance capabilities helps the sales team and the revenue generators do their thing more efficiently. That's the way to think about it.